You're sitting across from someone you genuinely love. Maybe you've been alone for years, maybe decades, and you met someone new. The conversation shifts. They mention their ex's financial mess or casually ask what you're leaving behind. And suddenly, you realize something terrifying. You have no idea how to protect your own direct descendants without looking like you don't trust the person in front of you. Welcome to the inheritance paradox that nobody talks about until it's too late. Here's what most people miss. Love and money aren't opposites. They're competing systems running on different timelines. Love operates in the present moment. It's emotional, immediate, reactive. Money operates across generations. It's logical, delayed, protective. When you remarry late in life, and statistically, you probably will, you're not just combining two people. You're merging two entire financial ecosystems, two sets of offspring, two conflicting visions of what happens when one of you passes first. The math is brutal. A report first published by the Pew Research Center in 2014 and reconfirmed in 2022 analyzed data from the U.S. Census Bureau and the American Community Survey that was tracked by the National Center for Family and Marriage. The data is consistent that adults aged 55 and older are the fastest-growing demographic for remarriage in America, and the trend line for 65 and older is actually increasing. While younger generations are becoming progressively less likely to remarry after a divorce or the passing of a spouse, senior Americans are bucking the trend and tying the knot again. Additionally, estate attorneys and financial planners largely agree that in 60% of those remarriages, the new spouse, whether through intention or simple inertia, inherits assets that the biological heirs expected. Sometimes it's just default beneficiary status. Sometimes it's intestate laws in your state. Maybe a forgotten 401k, or maybe a house that passed into joint tenancy. Perhaps a will was updated after the wedding, but not with the precision it should have been. You want to protect the inheritance of your direct descendants without sabotaging your new relationship. That's not paranoia, that's arithmetic. The first move seems obvious, but nobody does it. You need to know exactly what you have. Not approximately, exactly. Every account, every property, every policy. Most people in their 50s and 60s have financial debris spread across decades. Old employer retirement accounts, inherited assets, investment properties from different life chapters. You probably don't have a complete list, neither does your new spouse. And when you pass on, your executor will spend months finding things, and in that gap of time, assumptions get made. The new spouse moves into the house temporarily. The jointly held checking account becomes their default asset. The emotional weight of their grief gives them a kind of moral authority over your assets. So, prepare in advance of marriage with a single document, a spreadsheet, or a password-protected binder setting forth account title, account number, current balance, beneficiary designation. Then, and this is where most people flinch, you cross-reference the beneficiary on every single account with what you actually want. Your will might say everything goes to your heirs, but if your brokerage account lists your spouse as beneficiary, your brokerage account wins. Legal hierarchy. It overrides the will, every single time. This is the motif that will haunt you, the gap between intention and architecture. Most people pass intestate, which means without a will, but most people who do have a will forget that it's just one layer of a much larger financial ecosystem. The majority of assets transfer through what's called non-probate channels. That means they never touch your will. They go straight to whoever you named on the account. Retirement accounts, life insurance, transfer on death deeds. investment accounts. These bypass your will entirely. Your will only controls what's left, which for most people is almost nothing. So, here's the uncomfortable realization. You can write the most carefully constructed will in the world, and it might not matter. Your direct descendants could lose everything, but not because of malice, but because of an outdated beneficiary form you signed in 1997 and forgot about. Remarriage creates a specific vulnerability because the new spouse has a legal claim on certain assets. Survivor benefits, community property rights depending on your state, spousal elective shares. In some states, a surviving spouse automatically gets a percentage of your estate regardless of what your will says, and that's not negotiable. But here's where most financial advisors get it wrong. They tell you to set up trusts. And trusts are useful, but they're not a set-up-and-forget estate tool. They require maintenance. They require clarity. They require your family to actually use them, which means explaining the system to your heirs while you're alive, which means admitting you don't fully trust your new marriage, which in turn creates the exact tension you were hoping to avoid. So, what actually works? It requires splitting your assets into categories, and this is the real mechanism most people never hear. Category 1. Assets you want to flow through your estate. These go into your trust or get clear beneficiary designations pointing to your heirs. This might be real estate, jewelry, sentimental items, money that's truly meant for the next generation. Category 2. Assets that might be appropriate for your spouse to inherit. This is the emotional negotiation disguised as math. Maybe it's your home. Maybe it's enough liquid assets so that they're not devastated financially if you pass first. This isn't betraying your heirs. This is acknowledging that your spouse is also a human who contributed to your life, and there's a dignity in that, even if you need guardrails. Category 3. The hard one. Assets specifically protected from probate through mechanisms your spouse can't touch. This is where it gets technical. A QDOT, a qualified domestic trust, allows you to provide for a non-citizen spouse while preserving assets for your progeny. An irrevocable life insurance trust removes the spousal benefit from your taxable estate and names your heirs as beneficiaries, not your spouse. A limited partnership or family LLC creates layers of ownership that make it harder for a surviving spouse to liquidate everything and remarry again. These sound like conspiracies, but they're just structures. The uncomfortable truth is this: the more you love someone, the more you need these structures. Because structures are not about trust. They're about removing temptation. They're about protecting your spouse from making desperate decisions and protecting your heirs from having to sue their step-parent. A well-structured estate is actually an act of compassion toward both. But here's where the flaw drops. Most people think the risk is their new spouse deliberately stealing from their heirs. That's Hollywood. The real risk is slower. It's the surviving spouse, alone and grieving, making reasonable financial decisions that happen to benefit them. They pay themselves a property manager's fee for maintaining the rental properties. Reasonable. They take a loan from the estate to cover unexpected medical expenses. Understandable. They live in the house rent-free for 20 years while your heirs wait for their inheritance. Each decision is defensible, but collectively, they drain the estate over time. And your heirs, watching this unfold, have to choose. Do I sue my grieving step-parent? Do I damage my relationship with this person who raised me, or didn't raise me, who I barely know? Do I spend $50,000 in legal fees to recover $100,000? The math of grief is different from the math of finance. Grief makes people passive. The other scenario is darker. The new spouse remarried again, or spends down the assets, or simply passes before your heirs inherit, and suddenly your careful estate plan transfers everything to a third spouse's family. People who have no connection to you, no obligation to your legacy. This is not hypothetical. This is the pattern that repeats thousands of times a year. So, what's the moral compass shift? You cannot protect your inheritance without having explicit, difficult conversations with your new spouse before the marriage happens. Not after. Not someday. Do it before the marriage. This isn't romantic, but romance without infrastructure is just sentiment, and sentiment doesn't pay the tuition of your progeny. The conversation goes something like this, translated from legal speak into human. I love you, and I want to make sure that if I pass, you're taken care of. Here's what I'm thinking. I'll leave you X amount, and you maintain financial security. The house becomes a life estate. You can live here as long as you want, but it goes to my heirs when you pass or move or remarry. My retirement accounts go directly to my heirs, because that's what makes sense for tax purposes. We'll set up a joint account for household expenses, and we'll review this every 5 years, because our situation will change. So, set an appointment with your estate and tax advisors and get it all figured out and in writing before you say, I do. Any resistance to such sound financial and inheritance planning by your intended spouse may actually be a red flag that you should carefully consider prior entering into this new marriage, if at all. Focus on facts and not emotion, because the courts only care about the paperwork.